आज सुप्रीम कोर्ट में दिल्ली दंगों के मामले में काफ़ी लंबी आर्ग्यूमेंट के बाद शर्जील इमाम और खालिद की बेल को खारिज कर दिया गया, बल्कि 5 अन्य आरोपियों को जमानत दे दी गई।
The courts has consciously avoided a collective or uniform approach. Each appellant has been assessed on the basis of the role attributed, the nature of the material relied upon, and the stage of the proceedings, strictly within the limited compass of adjudication for grant of bail. This court is satisfied that the prosecution material taken at face value as required at this stage discloses a prima facie attribution of a central and formative role by the appellants in appeals arising out of SLP criminal number 14165 of 2025 and SLP 14030 of 2025, Umar Khalid and Sharjil Imam in the alleged conspiracy. The material suggests involvement at the level of planning, mobilization, and strategic direction extending beyond episodic or localized acts. The statutory threshold under 43D5 of UAPA therefore stands attracted qua these appellants. While the period of incarceration undergone by these appellants is substantial and has been duly considered, the court is not persuaded that on the present record, continued detention crossed the threshold of constitutional impermissibility so as to override the statutory embargo. The complexity of the prosecution, the nature of evidence relied upon, and the stage of the proceedings do not justify their enlargement on bail at this juncture, as noticed in detail in the discussion made herein above. Hence, the appeals arising out of SLP criminal 14165 of 2025 and SLP criminal number 14030 of 2025 stands rejected. We reiterate that courts are under constitutional obligation to ensure that criminal proceedings, particularly those involving prolonged pre-trial incarceration, should progress with utmost expedition and the accused are not left to languish in jail. At the same time, the court is mindful that pre-trial detention, even when justified by the statute, cannot be permitted to continue without regard to the progress of the trial. The restraint on liberty contemplated by law must proceed alongside a meaningful advancement of the prosecution. In the present case, having regard to the reliance placed upon the protected witnesses, this court considers it appropriate to provide a defined point for consideration of their prayer for grant of bail. We are of the opinion that on completion of the examination of the protected witnesses relied upon by the prosecution or upon the expiry of the period of 1 year from the date of this order, whichever is earlier, these two appellants would be at liberty to renew their prayer for grant of bail before the jurisdictional court. In the event of such prayer being made, it shall be considered on its own merits, having regard to the stage then reached in the proceedings before the trial court and without being influenced by the impugned orders or the present order. This course gives effect